Welcome, everyone. It is Wednesday, May 19th, 2021. Welcome to Montgomery County Republican Club's Direct Line program with our host, Mark Unkefer and Jackie Saxton. Our special guest is Thomas Jipping of the Heritage Foundation, Senior Legal Fellow of the Edwin Meese III Center for Legal and Judicial Studies. Take it away, guys.
That is a mouthful of a title.
Yeah, I made sure my mother saw my business card, so just so she knows I've got a real job.
They're extra large, are they? Well, Tom, welcome back. We had a great
Thank you.
show in the fall. I know we were talking, I think it was really in the lead up of the nomination process, and a lot has happened since then. So it was great to have you back to talk about the Supreme Court.
Thanks for having me.
So one of the I guess the first question is what can we say about the addition of the latest Justice Barrett? Has it?
Well, I think if people were watching the process last fall, that they saw pretty clearly through her confirmation hearing as well as the debate about her nomination what kind of justice she is. It's worth saying that the temptation to make a judgment about a justice on the basis of one decision or something like that can be great, but I hope that people resist that temptation because, of course, federal judges serve for life, and it's the long term, not the short term, that really matters. I think she's already establishing herself both in oral arguments and she started writing opinions that she'll be the kind of justice that her previous academic record suggested that she would be. She's an originalist. She believes the Constitution is the original meaning of its words. It's the Constitution as written, and she believes judges should be careful and impartial in applying that in their cases, so that judges don't do more than what they should. She has, I think, a very traditional view of the courts and of the Supreme Court, the view that I think America's founders had when they designed the judiciary. So I think she was a terrific addition to the Supreme Court, not only because she replaced Ruth Bader Ginsburg, who took the very opposite approach, but I think just on her own merit, she's exactly the kind of judge that our system of government needs. And frankly, she just seems like a really good person. As people, I'm sure, remember, mother of 7 and active in her church. She takes her faith seriously. She just seems like a really good person, very grounded in her beliefs. And I think she's going to take the right approach to deciding cases.
And it certainly seems like so far we haven't seen much after the initial, guffaw from the left. We haven't seen too many headlines in the news. Amy Coney Barrett slandering the legacy of Ruth Bader Ginsburg or anything absurd like that. So it seems like the left has kind of calmed down on that. Maybe it's out of office, but
just wait. I think because I think, and this is why I mentioned the temptation to judge judges on the basis of their latest decisions. The left's view of the judiciary is a very political view, which means really all they go on is whether a decision comes out the way they want. And they'll brand a justice as good or bad based on that. So, the next time there's a decision that they care about that Justice Barrett is on the wrong side of, the knives will come out. And of course, the Supreme Court has accepted a significant abortion case, which will be argued in the fall, and a lot of attention will be paid to that. It's unfortunate that the left and the media, maybe those are the same thing a lot of the time, but the left and the media, that's really all they talk about is, whether you like or dislike a decision. And the real issue, which is whether the law was interpreted and applied correctly, just kind of gets ignored. But I'm glad she's there.
Well, and sorry, Mark. You want me to go?
I was just going to follow up on that and talk about that. That really gets to the fundamental difference, which is the left looks at courts as being kind of a policy tribunal, which picks the winners and losers based on the policy merits or as they see them, as opposed to trying to apply the law. And it's really puts both sides very much at cross purposes in what they anticipate from the court.
Yeah, what the left cares about makes them treat judges the way you would treat senators. In other words, what's your position on an issue? Do you vote yay or nay on guns or abortion or something? When in fact, judges handle and address issues in a very, very different way than politicians do, or they're supposed to. And failing to understand that, it's about the separation of powers. Failing to understand those differences means that you fail to understand how our system of government is designed, and that produces ignorant citizens. And when you have a system of government that requires citizens to be informed and to be involved, you really have a mess on your hands. And so I think the appointment of these justices and the decisions that they make, they do present opportunities to better educate our fellow citizens about how we should look at the courts and how we should understand what judges do.
So, and I wanted to go back on your point from earlier about the left judging our Supreme Court justices based off of the political outcomes of their decisions. And I think that it segues perfectly into the decision that we saw this week, that 9-0 decision regarding whether or not police can go in and confiscate people's guns from their homes. And I think that's an interesting one because, of course, 2A is something that is so politicized, and obviously the left is very go in, take their guns. I mean, I think that was like Pete Buttigieg's entire campaign strategy when he was running for president. So it is interesting when you do see, regardless of whether or not it was a Republican appointed Supreme Court justice or a Democrat appointed Supreme Court justice, that they all are very much like, this is the Second Amendment.
Now, but it's interesting, if that was a 6-3 decision, if the Republicans, were all on one side and the Democratic appointees were on the other, and the Democratic appointees were the ones who said, you can't search people's homes, the left would have cheered. If it was opposite, the left would have booed. The fact is, this is not about whether police should be able to go into your home and get your guns. The question is whether the Constitution permits police to do that. And this issue was so clear. It wasn't pro-gun or anti-gun. It was pro-Fourth Amendment or anti-Fourth Amendment. And the fact that 9 justices agreed on that means that it's a very fundamental principle, and we should really take a lesson from that's what we ought to focus on, not the particular issues of the case.
But has the media been interpreting it that way? I can't say I've followed up too much. I saw the outcome of that, but I haven't seen, is the left saying, oh my God, they're the Second Amendment's outdated and this decision is awful. Have we seen any kind of blowback from that in the media?
I haven't, and it's simply because the liberal justices were on board.
Right.
That's why I say if the liberals and the conservatives were divided, well, then you'd hear all kinds of
and that's crazy. It's like that people are reacting not even based off of their own opinions on things, but solely based off of the way that the people who identify as the same political leaning as them. I was like, oh, okay, well, they did this, so we agree with it. It's crazy.
It's interesting. Had it been framed slightly differently, you described it as a Second Amendment, where arguably it's primarily a Fourth Amendment case on search and seizure, and it could have been somewhat similar sets of facts, could have created
but I would argue, because, and I guess obviously I'm the example of that, is I see the word gun and I think Second Amendment, regardless of, even though this really was more about the Fourth Amendment search and seizure, I would think that the average American wouldn't be able to tell you off the top of their head what the Fourth Amendment is. And then they just hear the gun and they think Second Amendment.
So let me ask you about the Biden administration as they weighed in advance of that decision on what ultimately was the losing side. Any conclusions to be drawn from that?
No, I don't think so. The administration is clearly that's where you do focus on the issue. The administration is clearly anti-gun, anti-Second Amendment, and so those are the positions they're going to take, whether it's in executive actions, whether it's advocating legislation or taking positions in court. You know, that's their policy position, and of course, having won the election, that's their right to pursue their objective. I guess what I hope people will try to do is when the court issues a decision that involves guns, it does not mean that the court is pro-gun or anti-gun or pro this or anti that. That's for the politicians to do. And it's that distinction that we really need to help people understand better. Because otherwise the conflicts over the appointment of justices simply becomes the politics of the issues, the politics of the political positions. The Democrats who just recently introduced legislation to expand the Supreme Court, for example, one of the arguments they made was that, well, today in the Supreme Court, it's 6 Republican appointees and 3 Democratic appointees, and that's unbalanced. And it doesn't take long to understand that position makes no sense whatsoever. The idea that a justice decides cases based on their party affiliation. We don't even know whether these justices are themselves Republicans or Democrats. All we know is the party of the president who appointed them. It's that kind of misunderstanding that, of course, we now have members of Congress promoting that misunderstanding that I think we really need to constantly work to overcome. On
both sides, absolutely. And if anyone who doesn't understand it, highly recommend 3 Ring Circus on Schoolhouse Rock, because that's how I learned it. And
I totally agree.
So, Tom, the commission has gotten started, and I guess you mentioned before we were on that they have had their first meeting. First, what do you expect from them?
Well, the President's Commission on the Supreme Court was created in April by executive order. The president, when he was running for president last year, said he would appoint this commission. People were, as I'm sure you know, and your viewers and listeners know, the issue of court packing, that's where most attention has kind of coalesced in terms of if any sort of reform needs to be made by the Supreme Court, that's the one that everybody's focusing on. And people wanted to know what Biden's position was. He had taken a pretty negative position on that when he was a senator, and people wanted to know. Well, his advisors no doubt told him, try to stay away from that. So he kind of punted and said, well, I'll form a commission to look at some of these ideas. He's done that. And the commission had its first public meeting today, as a matter of fact. This commission is very different than other commissions, either on court issues or other issues. And it's different in a couple of ways, primarily because this commission is not going to make recommendations. There have been 8 previous commissions in the last 50 years looking at court reform issues. Every single one of them was tasked with making recommendations. That's why commissions are pulled together. This one is not. This one is tasked only with kind of reviewing arguments and making observations about the commentary and debate and sort of, I don't know, it's just sort of thinking a lot, I guess, but they're not going to make any recommendations, which means the potential here is really only for further confusing the American people about what courts are supposed to do and about what some of these issues really mean. It was a dodge for Biden to appoint the commission, but now that we see how it's constituted and we see what this kind of non-assignment, is, I think it's even going to be more useless at best and probably very misleading at worst. Even left-wing groups, by the way, groups like Demand Justice, Take Back the Court, the ones that are most aggressively pushing court packing, they don't like it either. They've criticized this commission for being, somewhere between a law school seminar and a, therapy group or something. I mean, the fact that it's not going to make any recommendations, it's not going to take any positions. And as you probably remember, when President Biden gave his address to Congress back in April, you've seen those before. A part of those speeches are always an opportunity for the president to mention issues, to kind of push buttons that his supporters, want him to mention. He said not a word about the courts. He didn't mention this. He had just appointed this commission. Didn't say a word about it. And that's what's leading people to think that perhaps he just sort of created this group. There's 36 members, 32 of them are law professors. That by itself is a bad sign for getting anything meaningful done. And he just sort of tossed this issue to them so that he doesn't have to deal with it anymore.
Sounds like what he was trying to do with the border. Here, Kamala, your problem. Bye.
It'll be interesting because, of course, there have been a number of proposals for possible change, perhaps change the size of the Ninth Circuit, create some kind of rotation. So if they don't make recommendations, is it possible that they could exceed their mandate, or do you just expect them to?
No, they're not going to do that. And the fact that the left is criticizing the commission, started criticizing the commission before it even started meeting about that point, means that that's the common understanding. I mean, I'm currently writing a paper for the Heritage Foundation looking at those previous commissions and actually looking at if they were created by legislation, if they were created by executive order. It's always stated in the action that creates these commissions what they're supposed to do. And previously it was always, we want you to study this issue and we want you to make recommendations. Otherwise, what is the point of getting 32 law professors together to chat about a topic, about what's on their mind? That is hardly worth a presidential commission.
Now, we've seen Justice Roberts be very, how shall I say, circumspect about the sort of institutional role of the court, and perhaps conservative's the wrong word, but reluctant to push the court or push decisions in a direction that would get the court entangled politically. And is a commission like this likely to give him a little bit more pause in some of the upcoming decisions, or for fear?
No, I don't think so, because I'd have to say to the left and to the Biden administration, if you wanted to intimidate the Supreme Court, if you wanted to intimidate Chief Justice Roberts, you got to do more than this to do that. And designing the commission the way they have, I think it ensures that that's not going to have that impact on the Supreme Court, because they're not going to suggest anything. A couple of years ago, Senator Sheldon Whitehouse filed an amicus brief in the Supreme Court. In fact, it was in a gun case that is now back to the Supreme Court. And they put in their brief, basically it was a warning, that said, if you don't decide this case the right way, we might seek to restructure you, this kind of thing. That's more of the direct threat, the attempt at intimidation. This commission, I mean, who cares if a bunch of law professors are, chatting around a cup of coffee? I mean, this isn't designed, I don't think, to be able to have that effect. And frankly, in that sense, I'm glad, because the heart of the court packing idea is an attempt to manipulate the Supreme Court's decisions by creating new positions and adding justice. It's the most direct threat to the independence of the judiciary that we can imagine. In our history, it's been rejected at least twice, not just once with FDR, but going back to the turn of the 19th century, the same issue came up and was thoroughly rejected. And so anything that kind of neutralizes an attempt to politically manipulate the courts like that, I think is good.
Let's look ahead at the upcoming cases. I think there was some news this week about a abortion case coming forward. Or we could talk about that, but we can also talk about some of the other cases that are being taken up that may generate more attention to the Supreme Court.
Yeah, the legislature of Mississippi passed a law prohibiting abortions after about 15 weeks of pregnancy. This is one of a couple of categories of abortion regulations that are currently fairly popular in state legislatures, one being, and basically what they do is that they're prohibitions on abortion. They're not just kind of some regulations. They're prohibitions, but they're prohibitions after a specific point, whether it's when the fetal heartbeat can be detected or a certain number of weeks. This one is a 15-week ban, which is a kind of halfway through the second trimester. It's at a point earlier than when the Supreme Court in Roe versus Wade said the state could ban abortion. And so that's why it challenges Roe versus Wade itself. It challenges really the core issue in Roe, which is, does the Constitution protect the right to abortion? The lower courts, the U.S. Court of Appeals for the Fifth Circuit, found it unconstitutional under Roe versus Wade. They did what they had to do, which is apply that precedent. That's why the focus is now on the Supreme Court, because only the Supreme Court can change its own precedents. But that's why it's a significant case. It's been almost 50 years since Roe versus Wade, which is absolutely amazing to me. And in fact, I was looking today at some of the data about public opinion on abortion. And over these last 40 to 50 years, the fact that most Americans oppose most abortions hasn't changed. It's absolutely remarkable that after almost 50 years of a relentless propaganda campaign by the media, by the left, by the Democratic Party and all that, it has not changed the basic position of most Americans. And I think that's very significant now that the issue will be back before the Supreme Court.
So let's talk about some of the other cases. Now we will, with the congressional deadlock of obviously a 50-50 Senate and such a narrow margin in the House, the expectation is that the Biden administration will have to do a lot with the administrative, with rules and regulations, with the regulatory process, and in particular in the area of sort of energy and environmental policy. Now that sets up, and I think this is a conversation that we had in the fall, but a challenge or a re-examination potentially by the courts as to the role of regulatory agencies. Now, let me try and summarize this. You can disagree with this or clarify, but up to now, the courts have given a fair amount of deference to what they would consider to be the expert agencies. So they've said, well, we may not be quite sure, but you're the expert. We'll let you do what you will and interpret the rules, the law, the way you do in carrying out the law with regulation. That has been challenged. There's been some suggestion that the court may come back and take a look at that and not give quite so much deference to the regulatory agency. So we may be setting up a bit of a clash, if you will, since some of the underlying statutes, particularly in environmental policy, have been around for a long time, and that deference has given the agencies a fair amount of wiggle room or given them a fair amount of latitude to go kind of take laws in new directions. I think that's a very long-winded setup, but I wanted to kind of get your take on that. Is something we should be looking forward to?
I think that's a fair description. What we're talking about here are, which branch of government should decide policy issues, and that branch of government is the legislative branch. The legislative branch makes the laws. And so the debate about the courts is whether the courts ought to do that. And the debate that you're talking about here is whether the executive branch ought to do that. Same issue, though. Which branch of government should be responsible for making our laws? And the deference that you're referring to, I think, has gone too far. It's one thing for Congress passes a statute and for executive branch agencies to implement that statute. And then in the course of implementing it, they have to make some judgments along the way. That's one thing. But if you give those executive branch agencies too much leeway, they can end up changing what Congress has put into statute. And that's where then you've got the executive branch making the law and taking that authority away from the legislative branch. So it's a very fundamental issue. It's not, each case involves its own issue. Maybe it's environmental regulation in one case or another topic in another. But the issue is much more fundamental than that. And I think you're right with the very close margins. I think people know that the Senate is 50-50, but they kind of forget that the House has a closer margin than at any time in probably 50 or 60 years, too. I think it's only a 9-vote majority for Democrats there. And therefore, there's either going to be a problem passing legislation at all, or if the House passes radical legislation, which they have been doing, it's not going to get through the Senate. What are you going to do? The Obama administration had the same challenge, and they too said, well, we'll just stack executive branch agencies with ideologues who will try to push the law in the direction we want through agency decisions and rules. And that's where the constitutional separation of powers comes in, and that's going to be challenged. And hopefully this Supreme Court will honor the system as our founders designed it and say, the ends do not justify the means. Just because you want a certain result doesn't mean you can get it any way by hook or by crook that you want. So those are the issue that's represented by the cases you're talking about is very significant for our system of government. And, greed is not attractive under any circumstances. And when you're politically greedy, it can push you to do things, to do bad things. And those things sometimes end up in court. So I hope the Supreme Court addresses those issues in a principled way.
So this might be a question with no answer, but when did we start shifting away from, okay, we have these 3 clear roles of these 3 branches of government to let's blur the lines between them or and what you were explaining between the executive branch and the legislative branch in order to push things through? When did we start moving away into this murkier ground that will hopefully end up in the courts to bring things back to where they need to be?
Well, I think when it comes to the judiciary, it was in the 1930s. You had obviously the Depression, which was a national crisis that affected people so directly that many people were willing to put some of these principles aside in order to achieve some very practical political goals. For about 150 years, the understanding of our separated system of government and limitations on government, there was a big consensus behind that. But when that crisis happened, people started asking, well, we got to get it done. We have to, solve this problem. And even if we do it in the wrong way, I think that's when the real shift away in a very practical sense began. And I think also with the growth of the administrative state, where you have just simply the magnitude of the federal government, the size of it requiring more and more executive branch entities to kind of manage and implement and all of that. You combine these kinds of things and, this is where you're going to end up. And our system is designed to work a certain way. You cannot expect to get the results of that design when you change it. You know, it's like any recipe. I mean, you won't get the final product if you change the ingredients. And that's what we have to decide, whether, you know, that's what we want out of our government and out of our system of government.
Well, Mark, I don't know about you, but I got a serious chill up my spine when he was describing what was happening in the Depression in the 30s. And there was this huge crisis, and the government was, and the people were willing to give up that power and say, well, we need to get things done. We need to get them through. And I'm thinking, isn't this just what we went through last year with COVID? Well, this is impacting the people so greatly, and we need to get relief through. And I mean, I had a serious sense of deja vu of with what you were describing and where we're at now. And is in a way, are we reinforcing that behavior then by saying, oh, well, like at this point, people have come over the past year or two during the COVID crisis to say, oh, well, maybe it's not so bad to rely on the government, and look where we're ending up. You know, people, you know, restaurants, now we're going back to 100% capacity. Restaurants can't find workers. And that is what the result of putting too much reliance on the government is. And it seems like COVID in a lot of ways reinforced that same thing you were describing from the 30s.
I think that's a very apt observation. Back in Franklin Roosevelt's first term, he was first elected in 1932, just as the Depression was underway. And he was elected promising that the federal government would get the country out of this crisis. It was during his first term that the Supreme Court was striking down legislation that really gave the federal government too much power. In 1935, the Supreme Court struck down the National Industrial Recovery Act. Now, they did it unanimously. This wasn't just the Republican appointees on the Supreme Court. But Roosevelt responded. He had a big press conference in March of 1935. And he said that circumstances can result in greater government power. In other words, emergency circumstances mean that government may have to have more power to do its job. It's exactly the point that you're making. That was exactly the point that led him to say we got to expand the Supreme Court and appoint justices who believe that. That's the issue. You know, is it's not a principle if you don't apply it to yourself. And so if the principle of limited government is valid, then we have to apply it across the board. Instead, it's when, you know, when it kind of sidles up to me personally and affected me personally, oh, then I'll rethink it. That's the situation we find ourselves in over and over.
And you're seeing people kind of reject that idea, at least in Pennsylvania, of, okay, we're going through a crisis. I don't know how to handle it. I'm going to turn it all over to the government and trust in them. You saw, I mean, yesterday, a rejection of that in Pennsylvania, where they voted to limit the governor's powers in these crisis situations. And at least we're starting to see that on the state level, people saying, and I could just be because of that particular governor, but that's a conversation for another time, of, well, whoa. We just got shut down for an entire year, and look at how many business went out. And maybe it's not such a good thing to give the government that much power.
Well, the same thing happened in Michigan. That's where I grew up. That's where my family is, where the state law allowed the governor to declare a health emergency for a specific period of time. And the law was crystal clear that after that period was finished, it's up to the legislature to extend it. And instead, the governor there acted as if the law said something else and just attempted to declare another emergency. That went to the state Supreme Court, and they unanimously said no. And you know, that's why we have constitutions. That's why we have courts, and it's why the kind of judge that we appoint to our courts is so critical. Because if you have judges who take that sort of flexible, ends justify the means, words don't really mean what they seem, blah, blah, blah approach, then law doesn't mean anything. And if there aren't limits on government, our liberty is gone. So that, you know, even it's in these crisis situations that the real test comes, whether that's a principle or just kind of temporary preferences in politics.
That's a natural setup to ask a question about the nominations that President Biden has made so far for the judiciary. Obviously, he has not had one for the Supreme Court, but there are other positions that are open. How has he been doing? What kind of people has he been nominating?
Well, the last several presidents that we've had have each taken over from a president of the other party. And that means that in their new administration, they've got to set up the whole kind of apparatus for identifying candidates to appoint to the judiciary. And so usually new presidents, they won't get around to picking nominees until maybe July or August. President Biden was out of the gate sooner than that. As I'm sure you know, President Trump was very successful in appointing judges, and the number of vacancies that President Biden had when he took office was fairly low. But even so, he's made over a dozen nominations to the federal courts, including several to the U.S. Court of Appeals. The Judiciary Committee, which even though the Senate is 50-50, is chaired by a Democrat, Dick Durbin of Illinois, and they've already held hearings on nominees. I'm sure that the Judiciary Committee will vote to report nominees out to the full Senate soon, so we're going to see confirmations shortly. I think it's clear that the Biden administration's priority is what the left-wing groups call diversity, both in terms of demographic diversity, but also professional diversity. They're really putting a lot of emphasis on this. Some of these left-wing groups say that Biden shouldn't ever appoint anybody who's been a corporate lawyer, for example. And so there's been a real focus on the background of these nominees, that they worked in maybe public interest law, or they were public defenders, or they were political activists in some way. Some of them are well qualified and actually have had some support from Republicans. But I think we're going to see, as a group, a much more political approach to judging in the nominees that President Biden has picked. You know, Jimmy Carter is the only full-term president in American history who did not appoint a Supreme Court justice. And so I think that the likelihood that President Biden will be able to do that is pretty good. But if there's any indication of his early judicial nominees, I think we're going to see what we expected to see, which is a very political approach to the law, a very activist approach to how much power judges have, very, very different than what President Trump appointed.
I know we talked. Go ahead.
I was going to say, do you anticipate seeing any changes to the Supreme Court during Biden's term? I think we anticipated, had Ruth Bader Ginsburg lived through to see the end of Trump's presidency, that she probably would have retired and let Biden choose a new nominee. Do you anticipate something like that happening with any of the current justices during Biden's first term?
Well, like I say, the chances, looking at the historical pattern, are that's probably more than a 50-50 chance that will happen. Justice Stephen Breyer is the oldest justice. He's in his early 80s. He's been on the Supreme Court since 1994, but he's in good health. And the independence of our federal judges is really a remarkable thing, and it's protected by our Constitution in a way more than really any other country on earth, to the point where federal judges leave their job or they retire when they choose to retire. Lots of people think they can predict. Lots of people think they can, read the tea leaves or whatever it is. But, Ruth Bader Ginsburg chose to stay on when she did, and Justice Breyer, if he leaves, it'll be on his terms. I think that's the way it should be. But I think it is likely that sometime in the next few years, there will be a vacancy, and President Biden will be able to fill it.
Hard to believe it's only been 6 months of this presidency. It felt like a lot longer.
So at the lower level or at the appellate level, there seems to be this phenomena of judges of a particular political affiliation timing their retirement. Do we see that at the circuit level or lower?
Well, it's hard to say that that's what they're doing, because the judges who have announced that they're either typically today, judges will announce that they will retire on some future date, whether it's a specific date or sometimes they'll say whenever their successor is appointed. About half of those are Republican appointed judges. So I don't think there's enough evidence out there to say that this is a pattern of some kind of politically timing anything. There's always groups of retirement announcements. That's been a regular pattern in the past. So I don't see any pattern there. One thing about unlimited terms is that you don't have all of the judges who were appointed at a particular time retire at the same time. They go when they choose to. So I don't think there's a pattern, at least that I see. But at the same time, there's about 40 to 45 lower court judges who retire on average every year. And that's going to happen regardless of who's president. So President Biden will have plenty of opportunities to appoint lower court judges.
Well, let me ask you as we're kind of getting up to the end of to take your crystal ball out, and are there particular cases that we should be watching that perhaps should end up on page one? Because we've already obviously talked about the abortion case coming up to Supreme Court. Are there other cases that you expect to have sort of similar kind of impact? Well,
I think as far as issues go, the most radioactive issues in cases that go to the Supreme Court recently are, abortion and guns, and they've got one of each on their docket for the upcoming term. They haven't announced all of the cases that they're going to consider in the next term. The Supreme Court's term goes from the first Monday in October through the end of June. So in the next 6 weeks or so, they'll be announcing decisions in the rest of the cases that they handled in the current term. And then they'll be announcing cases that they'll handle in the next term. And they haven't done all of that yet, but those two cases are, I think, very, very significant. And people, I really encourage people to pay, if they can, to pay less attention to who wins and who loses, and more how the judges arrived at their decision. How did they go about interpreting the Constitution with regard to abortion or with regard to the Second Amendment? How did they apply that in those cases? Because that's really the heart of what judging is about, and that's really how we can best evaluate the judicial branch of government. When it comes to abortion, I know that that's very difficult for most people. If they believe that there ought to be the right to abortion, then they believe Roe versus Wade should stay, and likewise on the pro-life side. But it's worth remembering that Roe versus Wade was a 7-2 decision. One of the two dissenters, Justice Byron White, was a Democratic appointee who himself was pro-choice. And yet he said, whatever I might think about the issue, the fact is the Constitution does not protect a right to abortion. And we all know that. And so we have to decide, is it better or worse for the Supreme Court to be manipulating the Constitution in ways that we like? We have to say no to that. We have to say that whether I like it or not, it's not a legitimate decision if the Supreme Court is manipulating the Constitution. And these cases present the opportunity for us to decide, to make that decision, and to hopefully embrace the principle.
Have you watched the documentary they made on Roe v. Wade? And would you say that was an accurate portrayal of the case?
I have not. I've heard discussions about it and read some reviews about it. It is worth remembering that was a real case with real people in real situations, even though it's in the courts. But it is a court decision. It's not a political issue. It's not a personal decision about whether to get an abortion. It's in the courts for a reason, and it has to be decided that way. I think it's much better. Personally, I think it's much better off for our country that we, the people, decide what we want policy to be with regard to abortion than it is for the Supreme Court to decide that for us.
I couldn't agree more. Well, on that note, we are coming to a close. So, Thomas, as usual, thank you so much for joining us. You always bring such a very interesting insight and so much knowledge. I can't even fathom in my brain about the Supreme Court and everything to go with it. And Mark, thank you for having me back. It's been a while. And thank all of you for watching. And we will see you next Wednesday for another exciting episode of Direct Line.
Thanks for having me.